So to finish up talking about the titles, and kind of wish I'd have got this last type of title before we ended up the previous hour, but it'll be okay. But the last of the types of titles, again, is marketable title. We've talked about that a good bit already anyway. But we know marketable title is basically evidence or proof that you can convey the property either through selling it or giving it away or whatever or however you choose to dispose of the property. But we know we have to have both good title, which means you own it. And these are things, again, the attorney is going to be searching for. Make sure you have both good title, meaning you own it, and marketable title, meaning you can sell it or convey it to someone else. But then you also see towards the bottom of this marketable title, there are three acceptable forms of evidence to prove you have marketable title. There's three of them listed here. You see where it's Torrens certificate, that would work. Title insurance or abstract and legal opinion. And as said in the previous hour, the one you need to know is title insurance. Y'all, title insurance is marketable title. Y'all, the first one, Torrens certificate, I'm not going to get into that right now. That's really something a little bit different. The abstract and legal opinion, as you recall again in the previous hour, one of the things the attorney has to produce when they do their title search is an abstract of title, which is their legal opinion. But upon completion of the abstract, then the attorney should be able to say, this owner does own the property and they do have marketable title. In other words, there are no defects with the title. There's no clouds on the title. So it should be cleared to close for legal purposes. But that's what the abstract is. But I'm just telling you, title insurance, that's the biggie. If you have title insurance, that's the one I would remember if I were you. That's the acceptable evidence of marketable title. Okay. Now we need to talk about the deeds. So first of all, what is a deed? That's just a conveyancing document. This is the document that actually conveys ownership interest from one person to another. So seller signs the deed, bam, it's gone. That belongs to whoever it is they signed it over to. Well, believe it or not, there are different types of deeds. And often, I'll ask in a live classroom setting, I'll ask students a lot of times, if you own a house, what type of deed did you receive? And almost never will anybody be able to answer the question, well, what do you mean, what kind of deed? Deed's a deed. Well, no, it's not. There are different types of deeds, and it is important to understand this, especially if you're going to be in real estate. But first thing I want you to understand is, all deeds, regardless of which type, all do one thing in particular, and that is they convey ownership rights from one person to somebody else. Y'all got something in my eye, sorry. But anyway, so all deeds convey ownership rights, regardless of which one, they all do the same thing. So then what's the difference? Well, the difference is the amount or extent of guarantees and warranties the seller is making to the buyer against title defects or issues with the title, stuff like that. So let's take a look at this. For example, on this slide, and obviously it's in your material as well, but here we're going to talk about a general warranty deed and then also one we call a special warranty deed. Now, if you're selling your house and you agree to convey via a general warranty deed, basically, if you're the seller, what you're telling the buyer is this: buyer, I guarantee you there are no defects in title, and there will never be a defect in title found from this point or at any point into the past. And if something does pop up, I'm responsible. I guarantee the title under any and all circumstances. Y'all, that's a lot of guarantees you make. Yeah, you might own it now, and you may have owned it for the last 20, 30, 40 years. But I'm just telling you, you never know what could have happened with the title or ownership of this property prior to your ownership. Right? You just never know. Now, hopefully, there are no issues at all and no problems. But if they are, and if they ever surface by using a general warranty deed seller, you're making the guarantees and warranties from now on that there will never be any defect in title, at least from the time that I owned it and any time prior to my ownership. Even if it was prior to my ownership, I'm still responsible, and I make full guarantees and warranties against defect. A lot of guarantees and warranties with general warranty. Now, another option is the special warranty deed. In fact, I will tell you, y'all, one of these two deeds is what you tend to see in probably 95% or more of your typical real estate transactions. Okay, it's one of these two deeds. Again, there are some other deeds, and we're going to talk about those and why they might be used. But these are the two primary deeds that you see used with a typical real estate transaction. Well, the second is the special warranty deed, and a lot of times you'll even hear it referred to as a limited warranty deed. Yo, same thing. Well, obviously, the word limited, or to kind of clue you in there, we know it does the same thing. It still conveys ownership rights to someone else. But with this type of deed, basically what the seller is saying to the buyer is this: buyer, I guarantee you there are no title defects. Nobody else gained any interest in this property while I owned the property. But I'm not guaranteeing anything that may have happened prior to my ownership. So that's why it's considered a limited warranty deed. But again, the official legal title is special warranty deed. But again, if you decide to use the general warranty deed, seller, you're responsible for anything that may have happened while you owned it. You're also responsible for anything that may have happened prior to your ownership. Y'all, again, that's a lot of guarantees and warranties you're making there with that general warranty deed. So here's a question I would ask. If you're selling your house, which one of these two deeds would you prefer to use to transfer ownership to the buyer? And probably, again, if you're the seller, you're thinking special warranty deed, right? But what if you're the buyer? If you're buying a house, which deed would you prefer to get? And again, typically most buyers say, well, I want the general warranty deed. I want all the guarantees and warranties I can get. So now we come to the bottom line here. Which one are you going to use? Or if you've already bought a house or maybe even sold a house, which one did you use? And again, I find most people don't know. And y'all, that's kind of a pretty, not a good thing, right? I'm trying to think of the best way to say it. But y'all, whoever your agent was did not do a very good job, in my opinion. Because y'all, this is important stuff right here. You mess up here, y'all, this could destroy you financially, potentially for the rest of your life. I mean, this is serious stuff right here. A lot of money at stake if something happens here. And if you're making all these guarantees and warranties come with a general warranty deed, you got a real problem here. So here's what we need to consider or think about when we're practicing real estate. If you recall in the previous hour, one of the things I was, an example I was talking about, y'all, when I'm getting ready to list a property with a homeowner for sale, if you recall, one of the first questions I always ask, and I got to have an affirmative answer to it, is, seller, when you bought the property, did you buy title insurance? And if you recall, there's two different types of policies, right? There's a lender's policy, and if they borrowed money from the bank to buy the property, I promise you they got a lender's policy. But then there's also the owner's policy. And I want to know, did you get or do you have an owner's policy? If you do, then it doesn't matter what kind of deed you use. Because with that title insurance, if a defect in title should ever pop up, you're going to be covered anyway. Y'all, that's what the title insurance does. It will cover you against all loss, all damages as a result of title defect on this property, even during the time you owned it or even if something happened prior to your ownership. That's why title insurance is so critical. You got to have that when you buy real estate. Got to have it. And just as a refresher, remember, it's just a one-time payment that you pay at closing. And I know some of you think, well, how much is that one-time payment? Y'all, that's going to vary depending on the value of the property. Obviously, the more value the property is, the more it's going to cost. But y'all are usually talking about several $100s, okay? But we know that once you pay that, you're covered for life, for as long as you and your heirs are still alive. Not just during the time you own it, forever, because you never know when a title defect could pop up. So again, if they can prove to me they have an owner's title insurance policy, then we have no issues. Let's just sell. But if they cannot prove to me, maybe they're pretty sure they have it, but I have no proof that they have it. They can't show me a policy. They can't find their closing documents that would indicate whether they bought title insurance or not. Then I'm going to have to assume you don't have it, right? Because I'm trying to protect my seller. So I want to make sure when we do sell, the contract specifies that we're using a special warranty deed. For you to use a general warranty deed and you don't have an owner's title insurance policy, that's just suicidal. That's crazy. And it's ridiculous to even do that. Now a question I might ask you here. What kind of deed is in the typical contract of sale where you operate, in the market that you're operating in? Because I will tell you, typically this is already pre-printed in the contract. It's not one of these areas where you fill in the blank. And unfortunately, I'm certain, this is why most agents don't understand these types of deeds. They don't care about it. They don't talk about it because they don't know anything about it. Because it's not something that we have to fill in the blank, right? So we never talk about it. It's in the contract, just already pre-printed there. The question is, what does the contract you use in your market, or if you're not licensed yet, which contract do you think, let me back up. When you get your license, do you think it's important to know what the contract says in terms of the type of deed that will be used for this conveyance? That's critical. Now, I will tell you, in the market that I work in, and in fact, even surrounding markets that I work in, I think the most common, the default, is general warranty deed. The contract will say that this conveyance will be made via general warranty deed. Well, again, seller, if you don't have proof of title insurance, again, that's a very risky thing to agree to do. So so when we get an offer, I find in the contract of sale where it says general warranty deed, and I just line out the word general. You just draw one, you're making a counter offer. I line out the word general and write in the word special, so that we all know we're now using a special warranty deed, not a general. But now, is that a counter offer if the seller does that? Yes. Could the buyer reject it and say, I'm not willing to do that? They could. But I will tell you, if the buyer rejects that, that's evidence the buyer agent does not have a clue what they're doing, because y'all, you got to educate your clients. Y'all, this is a lot of what this course is about. Why you have to know so much of this stuff, so you can educate your clients and help them walk through this process. It really should not be that big a deal if you understand the process. Basically, what you need to understand is this. Should whoever is buying the property, whoever the buyer is, should that buyer buy title insurance, an owner's title insurance policy? Yes. For crying out loud, yes. Anybody buying real estate needs to buy title insurance. Again, an owner's policy. And guess what, buyer? Assuming you do buy the title insurance, then it doesn't matter what kind of deed the seller uses, because you're covered if anything should happen or go wrong, or any issues with title to the property, title defects and whatnot. You're already covered, buyer, so it doesn't matter the extent of guarantees and warranties you're getting from the seller. You're covered. So why does it matter? And I think sometimes people might get in their mind that, well, a general warranty, that's just a stronger deed than the special. No, it's not. Again, every deed does the exact same thing, regardless of what kind of deed you want to use. The only difference between one deed from another deed is the amount of guarantees and warranties the seller's making against title defect. And again, buyer, if you get your own title insurance policy, then you're not at risk of anything the seller should or shouldn't do, right? You're covered. So it shouldn't even be that big a deal. But if I know or cannot prove that my seller has an owner's title policy, then obviously we just can't make the kind of guarantees and warranties that come with a general warranty deed. We just can't. That's insanity to do something like that. So we're going to use the special warranty deed. So hopefully you got those two down pat. Again, those are the two that you're going to be using closer to 100% of the time, but at least 95% of the time, when you're dealing with a traditional, typical real estate buying and sell transaction. But what other kind of deeds are there? Well, let's look and see. Y'all got a couple more here. And I will tell you, there's more than what we just go over here. Again, they all do the same thing, but let's talk about them. This next type of deed is what we call a quitclaim deed. It says this is a deed that releases the interest one has in the property to someone else. Typically where you see this is when, I hate to even talk about these, but a lot of times in a divorce case, if a couple's getting a divorce, more times than not, one or the other party, either the husband or the wife, will wind up with the house, okay? But say it's the wife that's going to get the house. They get to keep the house. Well, but the husband's name is still on the deed as owning at least part or half of the house or whatever. Well, what a lot of times the attorney will do, they will prepare what we call a quitclaim deed. The husband will sign that deed, and by signing the deed, what the husband is saying to the wife is, any interest I did or do own in this property, you can have it. It's all yours. But the main thing that you need to understand about the quitclaim deed, with this type of deed, there are zero guarantees and warranties against title defect. So in other words, the wife couldn't come back at some point in the future if they discover a defect in title and try to blame or create problems for the previous spouse, because there are no guarantees and warranties that come with this. So again, when you sign a quitclaim deed, you're just basically saying, whatever interest I do own in this property, you can have it. But I make no guarantees and no warranties against title defect. That's what you're saying. In fact, good chance you'll see a question on the exam. Which of the following deeds carries no guarantees or no warranties express or implied of any kind? Y'all, the answer they're going to be looking for is quitclaim. Okay? Y'all, there are other deeds that carry no guarantees and warranties, but this is the biggie. Y'all, again, this is the one you see used a lot in situations like I just described. So they're going to want you to know this one carries no guarantees, no warranties. Then there's also this tax deed. If a property goes up for sale, a tax sale, because the owner did not pay their property taxes, whoever makes a bid that's the highest bid, they win, they get the property, then they're going to receive a tax deed. Now I will tell you, there's a lot more that kind of goes into this. And I don't think we need to get into it right here. I don't think you need to worry about that for test purposes. I think the main thing you need to know for test purposes is if someone purchases a property at a tax sale, they're going to receive what they just call it a tax deed. And I'll just kind of say real quick, not a whole lot you can do with a tax deed. In other words, if I go bid on a property and buy the property at a tax sale, could I turn around tomorrow or next week and sell the property? No, you cannot. There are other things that would have to take place, and sometimes it could take up to a year to be able to clear title to that property for you to be able to do that. So, the tax deed basically says you've got the right to try to clear title and be able to do whatever you want to do with it. But again, main thing you need to know, if you buy a property at tax sale, what are you going to get? A tax deed. There you go. All right. Then there's a trustee's deed. Obviously, when the deed's being held in trust, these are not typical types of deeds that real estate agents are involved with a lot. Now, some are, but not many agents get into this kind of stuff. But again, the trustee's deed is when you have a third party that might be holding title to the property, maybe for a minor, until the minor becomes of legal age, and then it becomes theirs. So whoever that third party is, that they're considered the trustee, and they'll be holding the property or to be conveyed to them via a trustee's deed. And then there's the bargain and sale deed. And you see this a lot with foreclosures. When a bank forecloses on the property. Obviously, the seller could just agree to transfer the title to the bank without having to go through the legal process. Again, using foreclosures. And I will tell you, if you're not making your house payments, you're going to lose the property. So why compound the issues and require a legal action, a court action? That's just going to create more cost, more expense, and you're not going to be able to keep the property anyway if you're not paying for it. So what the seller or property owner could do is just work with the bank, agree to this bargain and sale deed, which means you don't have to sue me, we don't have to go to court, I'll just agree to transfer the title back to the bank, and then the bank can do whatever they want to do with it. All right. So, those were the types of deeds that, at least for test purposes, you need to have a little bit of understanding about. But then this next thing we need to look at are the characteristics of the deed. Now, if you recall, I said, all deeds do the same thing. Regardless of what kind of deed you use, what's a deed for? To convey ownership interest or ownership right from one person to another. And most deeds look almost the same. Whether using a special warranty or the general warranty or a quitclaim, if you're just looking at the deed, they all look the same. They all pretty much have the same information on them, regardless of what type of deed it is. So how do I know if it's a general warranty or a special warranty or a quick, how do I know what type of deed if I'm looking at it? Well, typically it will just say it in the deed. It will say this is such and such a deed. But regardless of, again, which type of deed, they all have the same type of information in the deed. And that's what we're getting ready to look at right now. What kind of information is in the deed? Now, by the way, again, if you recall, again, from a previous chapter, or we've already discussed it at some point, but remember there's two documents that I recommend every agent have in their hand. You need a copy of it before you list a house for sale, if you're representing the seller, or before you make an offer to buy a house for the buyer. There's two documents you need to have in your possession. One is a copy of the deed. You need a copy of the deed to that property. The other one was a plat, and we talked about some of that already. But as we go through looking at the information that you're going to see in the deed, these characteristics, hopefully you'll start to see why this is important information, why I need to know this stuff when I'm listing and or making an offer on the property. So the first paragraph of the deed is called the premises paragraph. And this is where you'll find the names of the grantor and the grantee, who's the buyer and the seller. Any facts that are relevant to this transaction will be identified there. And by the way, do you need to memorize every single one of these paragraphs and what's in each paragraph? No. But there are some things that, and I'll point them out as we go through, that they could very well ask you about just to make sure you know what it is. Okay. But but don't try to just memorize every single thing that might be in a deed. The next thing you see in this paragraph is something called a granting clause. That is one they like to ask about. Granting clause is just some words expressing conveyance. There has to be a granting clause in the deed. For example, if I'm selling my house to Tom, that granting clause might read, I, Frankie Griffin, hereby convey all interest that I own over to Tom. It's just some words that express I'm conveying this ownership to somebody else. That's a granting clause. Some words of conveyance. Whatever the consideration is has to be identified in this paragraph. Now remember we said there's two types of consideration. It could be valuable consideration or it could be invaluable. Valuable consideration would be the price paid. So if I'm paying $500,000 for this house, it will say it in the deed that we are, the buyer is paying $500,000 as consideration for this property. But if there's no money passing hands, then obviously that means it has to be invaluable. And I'm sure we all remember what that would be. There's only one type of invaluable, and that would be for love and affection. And if that's the case, it will say it in the deed that the seller is conveying to the buyer via love and affection. But whatever the consideration is, it has to be listed in the deed. And then we have to have an adequate description of the property that's being conveyed. Now I will tell you, most deeds, I won't say all because that's not true, but most deeds will not have the property address. Some do, at least in my market. Maybe deeds might look a little bit different in your property. But typically the description of the property would not include the address in most deeds. What it will include is the tax map number, or sometimes it says TMS number, and the legal description of the property, the lot, block, and stuff like that. But that's everything you're going to find in the premises paragraph. Now, the next paragraph is the habendum paragraph. I don't know about y'all, but habendum just looks like a word they would ask you about to me. But the word habendum just means you have the right to have and to hold. They could ask you that. What does habendum mean? It just means you have the right to have and to hold. But in this paragraph, y'all, this is where it will clearly state what type of estate is being conveyed. Is this a fee simple? Is this a defeasible fee? Is it a life estate? Y'all remember we talked about those again in an earlier chapter. But this is where you will find the answer to that question. It'll be in this paragraph. If there are any conditions that would affect the grant. Now, what are they talking about here? Y'all, restrictions. Y'all, if there are restrictions, y'all, if you're looking at that deed and you see some conditions that the owner would have to comply with, or restrictions that the owner must comply with, that y'all, that's called a deed restriction. And again, if you recall earlier chapter, y'all, anytime you hear the word restrictions, that means that's a defeasible fee estate. Remember, defeasible means restrictions. So, again, can't you see why this would be important to be able to know before you list or try to purchase a property for your client? Y'all, if nothing else, I want to know, y'all, are there any deed restrictions? And the only way I'm going to know for sure is look at the deed. And there you go. Y'all, the next paragraph is what we call the testimonium paragraph. Y'all, a lot of times you hear this called the execution paragraph, but here's where you'll find the date of conveyance. Y'all, the date that we are conveying this property from the seller to the buyer. It must have a competent grantor's signature. Now, who's the grantor? Y'all, hopefully you said the seller. Y'all, the seller has to sign the deed, and it has to be witnessed. But what about the buyer? Does the buyer sign the deed? Because it just says here you must have a competent grantor's signature. It doesn't say anything about the grantee. Y'all, because the buyer does not sign the deed. Only the seller signs the deed. And people, so, all right, so, well, why doesn't the buyer sign the deed? Y'all, that's the next question I usually get. Don't need to. Y'all, again, because of the granting clause we just talked about earlier. Y'all, if I'm the seller, I'm the grantor. Remember, there has to be a granting clause in there that says, I, Frankie Griffin, hereby convey all ownership, interest, or ownership rights to Tom. And then I sign it. Guess what? Tom, you now own all of it. Tom does not have to sign for anything. Now, Tom does have to accept it. You just say, yep, I'll accept it. And that's all there is to that. And y'all, we're going to talk more about this acceptance here in a second. But before we do, y'all, we need to talk about this term called acknowledgement. Now, you need to be a little bit careful here. Y'all, I could see where they would try to confuse you, trick you on the exam when it comes to this acknowledgement. But what is acknowledgement? Y'all, before you can record anything in the public record, it has to be acknowledged, meaning it has to be notarized. Y'all, that's what acknowledgement means. Y'all, it means we have to y'all, they won't let you record anything in the public record if it has not been notarized. Y'all, it has to be, y'all, that's what acknowledgement is dealing with. But y'all, once the deed is notarized. In fact, what you'll find is, and maybe if you've ever bought or sold a house in the past, even before you get your license, you may not remember this, but when you were at closing, what happens a lot of times, y'all, once we're completely done, the buyer has signed everything they're supposed to sign, the seller signed everything they're supposed to sign. But in this case, say the deed in particular, the seller has signed the deed and it's been deeded to the buyer, the property has. A lot of times at that point, the attorney will call in one of their paralegals, which are usually notaries, and they just kind of come in, and then they'll actually witness the seller signing the deed. Y'all kind of said once they sign it. But actually, once the seller's ready to sign that deed, because that has to be notarized because we're going to record that in the public record, they'll bring somebody else in, usually one of their paralegals. They'll witness the seller signing the deed, and then that notary will actually, or the paralegal will actually notarize the deed. Y'all, that's considered acknowledgement. Okay? Now, here's what they do that could be kind of tricky for you. You could very well get a question, something along the lines of, what is the purpose of acknowledgement? And I will tell you, and I don't like it when they do stuff like this, but y'all, it is what it is. One of your options, y'all, in your multiple choice options here, would be so that the document can be recorded in the public record. Well, y'all, it is true that the document has to be acknowledged before it can be recorded, but that is not the purpose of acknowledgement. The purpose of acknowledgement is to in fact, you see it here on the slide. It's also in your book, in your material. But yeah, it said the purpose is to certify the genesis of the grantor's signature. Y'all, that's what a notary does. They're certifying that Frankie Griffin is the seller and that Frankie actually signed this document in my presence. And then when they notarize it, they're certifying that this is a valid signature by the valid owner of the property. Y'all, that's the purpose of acknowledgement. So don't let them confuse you when they say, what is the purpose of acknowledgement? It's to certify the genesis of the grantor's signature. That's what it is, okay? And then again, after all that's done, again, now the seller just signed the deed, but the buyer does not need to sign it. All they have to do is accept it. Yes, I will gladly accept the property. And y'all, that's what they're talking about, the delivery and acceptance. That's all we're talking about there. Okay. Now, when it comes to recording the deed, y'all, a lot of people don't realize this, but there's 3 types of notice that you need to be aware of, and certainly for test purposes, y'all, they could ask you about any one of these 3 types of notice. Y'all, the first is what we call constructive notice. Y'all, constructive notice just means I have recorded the transaction in the public record. In other words, I've given notice to the public. This is now my property, not yours. Stay away. That's public notice. That's what constructive notice means. But actual notice just means we have not recorded the document in the public record. You know, in fact, I ask this question a lot because I don't think a lot of people realize this. But, you know, if you're buying a house, do you have to record the deed in the public record for it to become valid or legal? And the answer is no. It does not have to be recorded in the public record. It's still yours. It's still valid. It's still legal. It's just that there's no public notice has been put out at this point. Y'all, that's just called actual notice. Again, actual notice just means it's not recorded in the public record. It is still legal. It is still valid. It's just not recorded. Which is probably not the best idea, by the way. But y'all, there's no law that requires you to record anything in the public record. But then this third one is inquiry notice. And now this is a little bit different from these other 2. But y'all, let me just ask you, do you think it would be a good idea for anybody signing, especially a legal document, should that person read and understand what they're signing before they sign it? Yes. In fact, by law, the law says that. The law requires that before you ever sign a legal document, it is your responsibility to ensure that you understand what you're signing. If there's anything in this document you're not sure what it means, you don't know, you don't understand it, then you have an obligation to inquire into it. You better start asking some questions and make sure you fully understand what you're signing. Y'all, that's what inquiry notice means. So in other words, y'all, inquiry notice just means once you've signed a legal document, you cannot come back later and say, but I didn't understand that. Nobody explained that to me. I didn't realize that's what I was agreeing to. Too late. Because you had the opportunity to inquire into it. You should not have signed it if you did not understand what you were signing. That's what inquiry notice means. Question again they like to ask a lot on the exam. Why is it important to properly record the deed? We just talked about recording the deed. Do you have to record the deed in the public record for it to be legal and valid? No. But should you? Yes, I would think so. As it says here, once you sign the deed, your property is considered transferred from the seller to the buyer. So we know that's done. It's legal. It's valid. It's now yours. But should you record the deed? Yes. If you do not record the deed, and let's say several years later you decide to sell the property, and the attorney's trying to do their title search. When they go to search the public record, it's not there. There's no evidence that you actually own the property. Doesn't mean you don't own it. It just means there's no evidence you own it. The attorney has to be able to prove you own the property. Remember that was part of that. That's the good title. And if it's not recorded, now you're going to have to prove it, seller. In other words, you better have a copy of that deed, and you better not lose it. Because if you don't have it recorded and you lose that deed, you're done. You cannot prove you own the property. That's a problem, I would think there. And obviously, if you can't prove you own it, that means you cannot produce good title. You're not going to be able to sell or convey this property to anybody else. It would be very risky, to say the least, to not record the transaction. Put it in the public record, then that way, if you do lose your closing documents, it should be on file with the county. Should be recorded in the public record, and then that way you would have no issues.